9 felony charges for the owner of Italian Herbs Dispensary in Ashtabula County. 9 F5 felony charges of drug database mishandling, or ORRS mishandling, which, for those of you who do not know, ORRS is the drug database system that Ohio is using for our medical cannabis up until very recently. So, welcome to another episode of Rodney Hash, first off. I want to give you guys some context. First off, I will start off by saying I did, as you can see from the thumbnail and from the title of the video, I did actually get to go to court and witness the entire hearing of her plea and her sentencing. And this is a pretty wild story, guys. So let me start off from the beginning and give you guys the full context so you guys understand where I'm coming from and where my perspective was along this entire journey. And if you guys don't want to hear any of that and you guys already know the full context and you just want to jump straight to the hearing, I will leave a timestamp down in the description and right here too. So with that being said, how did I first find out about all this? Granted, yes, I did grow up in Ashtabula County, but I don't spend a lot of time there now. So how did I find out about this? Well, as a lot of you guys know, being Rodney Hash, a lot of people that are whistleblowers tend to come out and reach out to me because they don't feel like they have anywhere else that they can go to be able to tell their story, especially if they want to continue to stay in the cannabis space. There is not a lot of jobs, especially if you're in Ashtabula County. Italian Herbs is pretty much it. There's a middle field grow facility, I think the Botanist, and I wouldn't recommend going and working with them either. A lot of these jobs are not great. But, so I had a victim, someone who was, as she puts it, she was sexually harassed by the owner of Italian Herb's cousin, Alex Orlando, which if you live in Ashtabula County, you may also recognize that last name from the Orlando brothers, because that's the family that he's from. For those of you who aren't aware, the Orlando brothers is a grocery store in Ashtabula County. There is a series of them. There used to be more. Over time, a lot of these large corporations like Walmart have kind of overtaken cities, but the Orlando brothers was a very large grocery store chain. So the other family that's involved in this, which is the Laurellos, just Laurello, a lot of their money comes from the railroad company, among other things that they've done in Ashtabula County. They are one of the wealthiest families in Ashtabula County. So I had this victim come up to me telling me, hey, so this is the story of what happened to me. At this point, I'm no longer working at Italian Herbs. I was sexually harassed. When I did finally report it to Jess, because it had been ongoing for quite a while, she didn't know how to handle it because that's just the owner's cousin, but she was still getting sexually harassed. So the question becomes, what do I do? Or what does she do? Well, she eventually reported it to Jess. And what happened? But she got fired a week later. That's coincidental. That's really funny. But that's where this whole thing started. And now that victim did reach out to me when that whole thing originally went down. And I didn't touch on it too much because I didn't really have a large amount of evidence. Yes, I can see that she was being harassed, the text messages, weird things with Spotify and so on and such forth. But I just didn't know what to say or what to do on it. So I kind of let it sit on the back burner. I told a few people in person, as I do a lot of these stories, because I have a lot of them that I just can't always tell you. So the next thing was she came to me, and eventually, very recently, she showed me charges. These charges came about because of her. Now, keep in mind, she did already go to the sheriff. Her and her lawyer went to the Ashtabula County and tried having them handle it. They had a letter that was given to Jess saying, hey, I tell you what, we don't even gotta, we can settle this outside of court. They tried having an agreement. Italian Herbs didn't want anything to do with it. probably because they knew that in Ashtabula County, they were pretty safe. And believe me, at the end of this, you are going to see exactly how safe she really is. And it is. And it's insane. Because if I had gotten 9 felony charges, let me put it to you guys this way. Sidebar. So when I was 18 or 19, I got in trouble for selling weed. Not to a kid or anything like that. Even when I was a kid, I sold it to adults. I never sold it to a kid. But I got caught selling weed. For a first-time offender in the first-time offender program as an adult, I was given, I think it was 9 months probation, 6 to 9 months probation, a large amount of fees. I eventually got all of it expunged, but I did have to go through it. I was harassed by the detectives. I spent 9 days in jail. I turned myself in on a warrant. They almost didn't want to give me a PR bond until I told my public pretender that, hey, like, you know, I turned myself on a PR bond. There's no reason to not let me out. Give me a PR bond, dude. I turned myself in on a warrant. There is no reason that I cannot have a PR bond. I am not a flight risk. They eventually gave it to me. I eventually got to plea out. But so that's a lot more than what she got in this. And I'm not going to spoil it right away, but that is a lot more than what Jess got in this case. And that wasn't even a felony I was facing. I was facing a minor misdemeanor. So, yeah. So, when the victim showed me that letter, I knew for sure this is legit. Not too long after that, these charges came about. Why did these charges come about? Didn't go through Ashtabula. So, where did it come from? Well, it came from the state AG, Dave Youst, because her attorney reached all the way out to the state AG, and the state AG had to get involved. Why? Those drug database mishandling charges. Where do you think those came from? Jess, and I found this part out in the court hearing, and you guys will see exactly what I'm talking about. Jess pulled this girl's information up from her home computer. Keep in mind, the harassment had stopped a little bit. She changed her phone number, I don't know if she changed her address or what else, but she changed her information. And then all of a sudden, the harassment continued again, and she couldn't figure out why. And then come to find out, Jess pulled her information up from her home. That's what I gathered from that court hearing. Because obviously she's the victim. None of this would have come about if not. And in the court hearing, the prosecutor told them told the judge there was no victim in the case. Now, the only reason there's no victim in the case is because the plea bargain that she pleaded down to from 9 felony charges of drug database mishandling, and if she would have pled guilty to any one of those could have made it to where she could no longer operate in the cannabis space. Did you guys know that? A drug database law. That's the type of felony. Not every felony will disbar you from being able to operate in the cannabis space. But when I was looking it up with my AI, multiple of them, just to double check myself, that could get you to where you can't work in the industry. Any one of those. She pled down in a plea bargain. Keep in mind, just entering a plea, she was granted at least 3 continuances. First American Protection Agency in Missouri, in a case, was just forced to enter a plea. He didn't have an option. He didn't have the option to do a continuance. But Jess was. Now, I'm not saying that that's impossible. She just has more money and a better lawyer. But it's weird that she was allowed to have 3 continuances before eventually her lawyer was able to argue and come to an understanding. Jason Fairchild was her lawyer, by the way, and I'm sure he's probably watching this too, because he was watching my stories and everything else that I posted about it since, as well as a lot of Jess's friends, which tells you that they're concerned about this. They don't like people knowing about this. And I also found out Jess has ties to media. I called Fox 8 News. I called the local Ashtabula County, multiple local Ashtabula County newspapers. No one would touch this story. Why do you think that is? The one dispensary in the entire county that is facing drug database mishandling, like felonies. One of the wealthiest families in the county is facing 9 felonies. No one wanted to touch it but me. That's why I was the one in the courtroom recording. So, where was I with the victim? So she sent the paper off to them. She sent it to the state AG. The state AG made those charges. And now here we are. So, with all of that being said, this is the hearing. And I want you guys to see it firsthand for yourself. This is the entirety of it. As you guys can already see, there's closed captions. So those closed captions will continue into the court hearing. The sound may be a little bit more difficult, and I apologize for that. Just is what it is. I didn't actually have the opportunity to give the judge my mic or anything like that. So I was just going off my cell phone's mic. But I did capture everything. I think it came through. So I hope you guys enjoy this as much as I did, because this is absolute insanity, and I'll spoil it for you guys. She only got a $2,500 fine in court fees. One of the wealthiest families in the county. She didn't even get probation. She got 9 felony charges, dropped down to 1 felony charge of obstruction of justice. That obstruction of justice charge, would you believe that that wouldn't disbar her or make her ineligible to work in the cannabis industry? Funny, huh? All right, guys. I've said enough. I hope you guys understand what I'm talking about in the context. This is insanity that a sexual assault victim is not getting her justice. And I really hope and pray that her pleading guilty to this case means that there will be another case following up contingent to it, because she deserves justice, this victim. This is not okay. All right, guys. See you in the next one. See you after this.
Thank you. You may be seated. We're on the record in the matter of the State of Ohio versus Jessica Laurello, case number 25 CR 293. The defendant is present before the court, represented by her attorney, Jason Fairchild. The State of Ohio is represented by Assistant County Prosecutor Gene Barrett. Ms. Laurello, I have been provided with a written 3-page plea agreement, an Alford plea, which indicates to the court that it is your understanding and intention that pursuant to the case of North Carolina versus Alford, you will be entering a plea of guilty to this charge, understanding that the maximum penalty, and when I say this charge, count 9 amended to obstructing official business, a 5th-degree felony, punishable by a maximum of 12 months in state prison and a maximum $2,500 fine, with the understanding that the State of Ohio's position with respect to sentencing is that you will receive a fine in this matter and the imposition of court costs. Is that your understanding and intention?
Yes, Your Honor.
Please stand and raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth in this matter?
Yes, Your Honor.
Thank you. You may be seated. Would you state your full name, please?
Jessica Laurello, Your Honor.
And what is your age and date of birth?
My age is 34, and my date of birth is October 17, 1991, Your Honor.
And what is the highest grade level of education you've completed?
I have my bachelor's in science, Your Honor.
And do you have any difficulty reading, writing, and understanding the English language?
No, Your Honor.
Did you read, understand, and sign the plea agreement form that I made reference to?
Yes, Your Honor.
Did you do so in the presence of your attorney? And was he able to answer any and all questions you might have had in this matter?
Yes, Your Honor.
Are you a veteran of the military?
No, Your Honor.
Are you a United States citizen?
Yes, Your Honor.
Did anyone threaten you or promise you anything to get you to plead guilty in this matter?
No, Your Honor.
Have you used any alcohol or drugs, recreational or prescription, within the last 24 hours?
No, Your Honor.
Should you be taking some medication prescribed to you by a doctor that you are not taking for whatever reason?
No, Your Honor.
Have you ever been found to be a mentally ill or incompetent person?
No, Your Honor.
Are you suffering currently from any emotional, psychological, or concentration issues?
No, Your Honor.
Are you under the care of any doctor for any reason whatsoever?
No, Your Honor.
And you understand you're entering into this plea of your own free will?
Yes, Your Honor.
And you understand that this is what is called an Alford plea, in which you will be pleading guilty pursuant to the conditions set forth in North Carolina versus Alford, which I'm assuming your attorney has advised you.
Yes, Your Honor.
Now, the original indictment in this matter consists of 9 counts. It is proposed that you enter a plea of guilty to count 9, amended to obstructing official business in this matter. Mr. Barrett, what is the factual basis for the charge of obstructing official business?
Yes, Your Honor, this matter stems from a May 31, 24 Board of Pharmacy complaint and inspection by Sabrina Radke concerning the dispensary misusing the OARRS system, and the investigation indicated that the agents had come up from Columbus to Ashtabula County to do this investigation. They had come up here, they investigated, found some deficiencies with the dispensary's business practices, and also discovered that Ms. Laurello had at one time used the ORS system while she was not at work, but logged in on her personal computer. And this came out during the pendency of the investigation instead of right up front, and they were not able to produce certain records for the investigation, which was determined much later that the record-keeping system at the time was unable to pull back that distance, because a year had passed almost before this investigation was completed and brought to the prosecutor's office. And the agents could have faced physical harm in their driving up here to Ashtabula County and the ongoing aspects of the investigation. It stemmed from an anonymous tip of a former employee of the dispensary to the pharmacy board.
Now, there are several investigative agencies that have been involved in this matter?
Yes, Your Honor. During the time this case initially began, the Board of Pharmacy was the investigating agency. Then it transferred due to changes in the law to the Medical Marijuana Dispensary Board, which was a subunit of the Board of Pharmacy. And I believe Sarah Radke worked for that dispensary board, and then the involvement of Board of Pharmacy investigative agents also.
Have you consulted with these various investigative agencies to ascertain whether any of them have an objection to this?
I have, Your Honor, and the primary investigator, Ms. Radke, does not work for either of these organizations anymore. But I did speak to her. She has no issues. I also spoke to the chief investigator from the Board of Pharmacy, and there are other things they can do in-house if the Board of Pharmacy chooses to do so. And they have no objection to this case being handled the way it is.
And there actually is no specific victim to the offense that she's pleading to.
That is correct.
And you find this plea to be in the interest of justice?
I do, Your Honor.
Thank you. Now, Ms. Laurello, in an Alford plea, you are pleading guilty but protesting your innocence. What are your reasons for pleading guilty if you are protesting your innocence in this matter?
Your Honor, I maintain my innocence, but I'm pleading guilty by way of Alford to seek leniency from the court and to avoid the risk of a jury trial on the indicted charges.
Mr. Fairchild, you are in accord with this resolution on behalf of your client?
I am, Your Honor.
Thank you. Now, Ms. Laurello, do you understand that the maximum penalty that could be imposed by this court for the offense that you are pleading guilty to, obstructing official business, is 12 months in state prison and a $2,500 fine?
Yes, Your Honor.
Prison is not mandatory, nor is there a presumption for prison in this matter. Now, Mr. Barrett, the state's position of sentencing is a fine to be set by the court. Is the state's position that that would be the only consequence, would be the fine set by the court?
Yes, Your Honor. Ms. Laurello does not have any prior history. As a matter of fact, I think her record is clean. And placing her on community control in this matter would probably be a very high waste of resources for this county.
But she would be a convicted felon pursuant to this plea.
That's correct.
Is that your understanding, Mr. Fairchild?
It is.
Thank you. Now, Ms. Laurello, if I would sentence you to prison in this matter, do you understand that after you will be released from prison, you will have up to 2 years of post-release control? And that if you violate the terms and conditions of your post-release control, you could be returned to prison for up to another 6 months for each violation, for a total of 50% of the original sentence. Do you understand that?
Yes, Your Honor.
And that if you're convicted of a new felony while on post-release control, that besides being punished for the new offense, the sentencing court could terminate your post-release control and impose a consecutive prison term of 1 year for what time remains on your post-release control term, whichever is greater. Do you understand that?
Yes, Your Honor.
And that if I would sentence you to prison, you may be eligible under certain circumstances to earn days of credit up to 8% off your prison sentence based on your conduct and behavior while in prison. Do you understand that?
Yes, Your Honor.
Now, if I would make a determination to place you on community control, you would be subject to the court's standard terms and conditions of community control, as well as any special terms and conditions that I would have. And that if in the future, while on community control, you would violate those terms and conditions, you could be returned to this court. And if it would be proven to my satisfaction by substantial evidence that you were in violation of those terms and conditions, I could re-sentence you. And that resentencing could include sending you to prison at that time, sending you to county jail, adding additional terms and conditions, or extending the length of the community control to a maximum of 5 years. Do you understand that?
Yes, Your Honor.
Now, Mr. Barrett, is it the state's contention that a firearms disability would result as function of this plea?
Your Honor, it would not function under the state of Ohio disability for firearms use or possession, and I believe under the federal code, this is punishable by up to 12 months of incarceration, and I believe the federal code requires that it be punishable by more than 12 months.
Mr. Fairchild, is this your understanding of the status of the disability law?
It is, Your Honor.
And you have consulted with your client regarding
Correct.
that? Does she hold any professional license, Mr. Fairchild, that could be affected by this plea?
No, Your Honor.
Is she currently on probation or community control in any other court or state?
No, Your Honor.
And now, Ms. Laurello, do you understand that in this case you have a right to a trial and a trial by jury? By virtue of this plea, you are giving up or waiving your right to a trial by jury. Do you understand that?
Yes, Your Honor.
If you wish to exercise your right to a trial by jury, you would participate with your attorney in the selection of 12 people from this community who would sit as jurors, hear the evidence, and make a determination as to whether the state of Ohio can prove your guilt beyond a reasonable doubt. To do that, to prove your guilt of any offense beyond a reasonable doubt, the state must prove each and every element of that offense beyond a reasonable doubt. And to do that, the state would call a witness or witnesses who would testify against you. You, through your attorney, have the right to question or cross-examine any witnesses who testify against you. Do you understand that?
Yes, Your Honor.
You have the right to examine or inspect any physical evidence or documents introduced against you, both before the trial in something called discovery and during the trial. Do you understand that?
Yes, Your Honor.
You have the right to call witnesses in your own behalf. And if there would be a witness you wanted to testify who was unwilling to come in voluntarily, you have the right to ask this court to issue a subpoena to compel that witness to come in and testify. Do you understand that?
Yes, Your Honor.
You have the right to testify at that trial yourself, but absolutely no obligation to do so. You have the absolute right to remain silent in this courtroom during the time of the trial, and the prosecuting attorney would not be permitted to make any comment or argument to the jury regarding your assertion of your right to remain silent. Do you understand that?
Yes, Your Honor.
At the conclusion of the evidence portion of this case, the jury would retire to the jury room, and in order to reach a verdict, any verdict on any count, all 12 jurors must agree or be unanimous to reach a verdict. Do you understand that?
Yes, Your Honor.
Now, if you would make a determination to proceed to trial, and you would be found guilty, or in the alternative, if you wish to appeal any aspect of anything this court has done in this case, you must perfect that appeal by filing a written notice of appeal within 30 days of the date of your sentencing in the Ashtabula County Clerk of Court's office. It is my intention to sentence you today, so that notice of appeal would be due within 30 days of today's date. If there is a filing fee for that notice of appeal, and you don't believe you can afford to advance or pay the filing fee, you can make an application to this court. And if you qualify financially, the filing fee would be waived on your behalf. If you wanted to be represented by an attorney on the appeal, you don't believe you can afford to hire an attorney, that same application could be used to ask this court to appoint an attorney. And if you financially qualified, an attorney would be appointed to handle the entire appeal free of charge to you. And if the attorney needed the transcript of these proceedings, which they usually do, there's a cost for those transcripts. That same application could be used to ask this court to waive the transcript costs so that you can perfect your appeal. Do you understand your rights on appeal?
Yes, Your Honor.
Now, you are represented by Attorney Jason Fairchild, correct?
Yes, Your Honor.
Have you had an adequate opportunity to discuss this matter with Mr. Fairchild?
Yes, Your Honor.
Do you need any more time to discuss any aspect of this with him?
No, Your Honor.
Did he review with you his file materials, which would have included what I previously referred to as discovery from the state, whatever materials he got from the state?
Yes, Your Honor.
Did he discuss with you the potential witnesses that could testify against you, as well as witnesses you might be able to call on your behalf?
Yes, Your Honor.
Did he discuss with you any possible defenses that you might have?
Yes, Your Honor.
And did he discuss with you the penalties the court could impose in this matter?
Yes, Your Honor.
Are you satisfied with the time, advice, and professionalism of Attorney Fairchild?
Yes, Your Honor.
Mr. Fairchild, are you satisfied that this defendant is knowingly, intelligently, and voluntarily entering into this plea?
Yes, I am, Your Honor.
Thank you. This court finds pursuant to North Carolina and Alford that an adequate factual basis from the state's perspective was placed on the record in the Alford plea, and the court further finds that the defendant has stated reasons on the record for entering a plea of guilty pursuant to North Carolina versus Alford in this matter. Now, with respect to the 3-page written plea agreement, with respect to count 9, amended to obstructing official business, a 5th-degree felony, punishable by up to 12 months in state prison and up to a $2,500 fine. What is your plea pursuant to North Carolina versus Alford to that charge?
Your Honor, guilty by way of Alford.
The court finds the defendant has knowingly, intelligently, and voluntarily waived her rights and entered a plea of guilty to count 9, amended to obstructing official business, a 5th-degree felony, and the court will accept that plea and make a finding of guilt. Mr. Barrett, based upon the acceptance of that plea, is the state moving to dismiss the remaining counts 1 through 8 in this matter?
Yes, Your Honor.
That motion would be granted. Is there any reason we should not proceed to sentencing in this matter?
Nothing from the state, Your Honor.
Mr. Fairchild?
No, Your Honor.
Will both counsel waive the preparation and presentation of a pre-sentence investigative report?
The state would waive.
The defense does as well.
Thank you. Ms. Laurello, a few moments ago, I advised you of your appellate rights. I told you we were going to proceed to sentencing. We are proceeding to sentencing in this matter. If you wish to appeal any aspect of this case, it must be done within 30 days of today's date. Do you understand that?
Yes, Your Honor.
Mr. Fairchild, on her behalf.
Thank you, Your Honor. Your Honor, as was indicated in the written plea of guilty, the state defense would be asking that the court impose only a fine in this case, and if the state is concurrent with that, it would indicate to the court Ms. Laurello, she's a young, new entrepreneur in the community. She has no prior criminal history at all. Her and her family are business owners in the community. As you can see, she's got the love and support of her family here with her today, and the conduct that gave rise to the charges in this case and ultimately resulting in the negotiated plea involved what I term as a technical violation of a regulatory requirement in this case. I liken it to like a paperwork violation. I would indicate to the court as support for a fine only. The investigating officer from the Board of Pharmacy had indicated while this case was pending that they were okay with the reduction of these charges to a misdemeanor, which we were trying to work out and resolve this matter. However, the elected county prosecutor objected to that, which is why we ended up with the Alford plea to the obstructing official business. It would indicate that since this incident has occurred, processes and protocols have been put in place at the business to help prevent something like this from happening again. Obviously, with her not having a prior criminal history, the likelihood of recidivism in this case is extremely low. And as I would point to the court that under Revised Code 292913, it does state that if the offender is eligible to be sentenced to community control sanctions, the court shall consider the appropriateness of imposing a financial sanction pursuant to section 292918 of the Revised Code, or a sanction of community service pursuant to section 292917 of the Revised Code as the sole sanction for the offense. And I think based on these reasons, we feel and we would request that the court find that a financial sanction in this case is appropriate and impose same. Thank you.
Thank you. Ms. Laurello, is there anything you wish to say?
No, Your Honor.
Thank you. Mr. Barrett, on behalf of the state.
Yes, Your Honor, the state would be asking for a hefty fine in this matter, and as Mr. Fairchild did point out, this court has in other cases of persons with no prior criminal conduct who had the aberration of the law have also been fined without any type of community control or prison sentence. And the state is asking to comply with that. She is subject from 6 months to 12 months in prison, but I don't feel any type of prison sentence is necessary in this matter based upon her prior history and the steps actually that the pharmacy board has told me that the business has taken to prevent any unauthorized access to the ORS system in the future.
Thank you, Mr. Barrett. This court has considered the record of this proceeding, all of the information presented at this proceeding, the fact that both counsel have waived the preparation and presentation of a pre-sentence investigative report, and the fact that there is no specific victim in this matter. I've considered the overriding purposes of felony sentencing under the revised code and the seriousness of crime recidivism factors set forth, which are: number 1, to protect the public from future crime by this defendant and others; number 2, to punish the offender; and number 3, to promote the effective rehabilitation of the defendant while using the minimum sanctions the court determines accomplishes these purposes. All of this having been said, the court is familiar with the rather complex and unique circumstances of this case. I do find the sentencing recommendation of the state to be appropriate in this matter. Under these circumstances, the court will impose the $2,500 fine plus court costs, and the court does not see the need for any community control or any further punishment in this matter. She has no jail time credit, is that correct?
That is correct.
Correct.
Anything further on behalf of the defendant?
No, Your Honor, thank
On
you.
behalf of the state?
No, Your Honor.
Thank you, we are in recess.